Hello and welcome to the webinar, PTAB and the District Courts. My name is Bailey Reeves, and I will be in the background answering any Adobe Connect technical questions. If you experience technical difficulties within the Adobe Connect session, please use the Q&A box on the right-hand side of your screen, and our technical assistance team will help in any way possible. If you are having issues hearing over the phone, you may press *0 and an operator will assist you. Please note that as an attendee, you are part of a larger audience. However, to maintain privacy, the number and names of attendees will not be displayed. All attendees will be in a listen-only mode throughout the presentation, and as a reminder, today's call is being recorded. We will be holding a Q&A session at the conclusion of today's presentation. To submit a question, click on the Q&A panel located on the lower right-hand side of your screen. Type your question into the text field and hit send. This seminar is accredited for 1 hour of Illinois' MCLE credit. Please inquire if you wish to seek CLE accreditation in additional states. During the webinar, we will be providing 3 CLE codes. Please write these down. We will be mailing an evaluation form at the end of the webinar and will ask for the codes. If you have any questions regarding CLE, please contact CLE@brinkskilson.com. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce your moderator for today, Gary Roeske. Gary, you now have the floor.
Thank you, Bailey, and welcome everyone to our presentation on PTAB and the District Court. We have about 45 to 50 minutes worth of presentation, and we're going to leave some time for questions at the end. We have 3 speakers, as you probably know, on 3 different topics. The first topic may take about 20 minutes or so, the second about 15 minutes, the last about 10 minutes. Our first speaker is Jafon Fearson, and he's going to talk about the issue of IPR estoppel at the PTAB and district courts, and specifically the estoppel issue, as I mentioned. Then our second speaker will be Myung Shin. She's going to talk about concurrent proceedings before the PTAB and the district courts and whether the PTAB's decision is binding on the district court and related issues. And our third speaker is Alex Wong, and he's going to talk about the stay motion success rate and any discrepancies between the districts. So let's turn to our first speaker, Jafon Fearson, and here is his slide. Jafon, it's all yours.
Hello, everyone. As Gary mentioned, I'll be covering the scope of the IPR estoppel statutes and their interpretation between the PTAB and the district courts. We'll begin here with a couple of highlights regarding petitioner IPR estoppel. First, estoppel kicks in at the moment a final written decision is issued, and this is so even if the board's decision is on appeal. Second, estoppel prevents a petitioner from asserting invalidity on any ground that petitioner raised or reasonably could have raised. Third, estoppel binds both petitioner and its real parties in interest or its privies in the Patent Office, the district courts, and the ITC. Fourth, estoppel applies on a claim-by-claim basis. And fifth, estoppel is limited to those anticipation and obviousness challenges based on patents or printed publications. And thus, a petitioner will not be stopped from using, for example, a 102B prior sale or public use reference in a later invalidity challenge. Here, we take a look at the actual language behind the estoppel statutes. On one hand, we have 35 U.S.C. 315E1, which addresses estoppel within the Patent Office. And on the other, we have 35 U.S.C. 315E2, which addresses estoppel outside of the Patent Office. If we take a look at 315E1, we see that after a final written decision has issued, a petitioner or its privy or its real party in interest may not request or maintain a proceeding before the office with respect to a claim on any ground that the petitioner raised or reasonably could have raised during that inter partes review. And if we take a look at 315E2, we'll see that the standard here is essentially the same, except it stops a petitioner in the district courts or the ITC rather than the Patent Office. So what are those references or grounds that reasonably could have been raised in the IPR? The AIA legislative history provides some guidance, providing that petitioner is not expected to conduct a scorched earth search around the world that would have uncovered the prior art in question, but rather reasonably could have raised extends only to that prior art which a skilled searcher conducting a diligent search reasonably could have been expected to discover. A district court out of the Northern District of Illinois has given one example of how this showing may be made, providing that one way to show what a skilled search would have found would be to, 1, identify the search string and the search source that would identify the allegedly unavailable prior art, and 2, present evidence, such as expert testimony, why such a criterion would be part of a skilled searcher's diligent search. Another issue is who bears the burden of showing that a reference reasonably could have been raised. Interestingly enough, the burden differs depending on the forum. For instance, the district court places the burden on the patentee, finding that patentee must present evidence that a skilled searcher's diligent search would have found the newly asserted reference in a case out of the Northern District of Illinois. In this case, this was so because the Seventh Circuit requires that the proponent of an estoppel argument bear the burden. On the other hand, the PTAB places the burden on the petitioner, and in one example, the board found that petitioner did not show that a reference would have been found by a skilled searcher's diligent search by only providing a single search report by an unidentified searcher of indeterminate skill and experience, listing a mere 15 exemplary search results. And now we come to Shaw Industries Group versus Automated Creel Systems, which is the seminal Federal Circuit opinion addressing the scope of estoppel. In Shaw, the Federal Circuit held that estoppel does not apply to non-instituted grounds, and this includes grounds that were not instituted because of redundancy. The court provided that the IPR does not begin until it is instituted, and thus, arguments that were based on a non-instituted redundant ground were not raised, nor could they have reasonably been raised. The court provided that the plain language of the statutes prohibits the application of estoppel under these circumstances. So post-Shaw, we've seen a divergence between the Patent Office and the district courts regarding their interpretation of the estoppel statutes. Generally, within the PTO, estoppel has been applied much broader than outside of the PTO. And within the district courts, there's been uncertainty as to the scope of the estoppel statutes, where some district courts have applied the statute more narrow, while others more broad. These varying interpretations between the Patent Office and the district courts are not likely due to any variance in language between 315E1 and E2, with at least one district court commenting that the standard between the two is the same. Here, we take a look at how different types of situations where grounds are presented are generally treated by the district courts versus the PTAB. If we look to the left, our first scenario is where grounds are presented in a petition, the petition is instituted, and a final written decision is issued. Here, between the PTAB and the district courts, both agree that petitioner should be stopped from later raising these grounds. The second scenario is where grounds are presented but are not instituted. In this case, the district courts generally find that estoppel does not apply in light of Shaw's holding that the IPR does not begin until after it is instituted. On the other hand, the Patent Office has found that estoppel may apply to these non-instituted grounds. And in our last scenario, this is perhaps where we see the most disagreement between not only the PTAB and the district courts, but between various courts themselves. Here's a situation where grounds are not presented at all in a petition. Up until recently, district courts have found that in this scenario, grounds not presented are not subject to estoppel if estoppel does not apply to non-instituted grounds, as found in Shaw. And thus, by implication, grounds never presented are also non-instituted grounds. However, on the other hand, the Patent Office has generally found that estoppel may apply if the ground reasonably could have been raised based off of a diligent searcher's search. And as we will see in a later example, some courts are starting to agree with the Patent Office on this point. Here is an example of where a district court and the PTAB interpreted the estoppel statute differently regarding grounds presented but not instituted. For example, in a case out of the Northern District of California, Veronetta Health v. Ariosa Diagnostics, the court held that a ground that was raised in the petition but denied on the merits was not subject to estoppel. The court reasoning here that limiting IPR estoppel to grounds actually instituted ensures that estoppel applies only to those arguments or potential arguments that received or reasonably could have received proper judicial attention. On the other hand, in Koufax v. Uniloc, the Patent Office found that a prior non-instituted ground created estoppel in a subsequent proceeding involving that identical ground in a later filed IPR petition. Here, the board reasoned that petitioner reasonably could have raised the non-instituted covered business method ground in an IPR within 1 month of the covered business method petition's denial, and that the covered business method petition showed that petitioner was previously aware of the references. Next, this example shows that the district courts and the Patent Office also disagree with regards to whether petitioner should be stopped from raising grounds not presented at all in a petition. For example, in Intellectual Ventures versus Toshiba Corp., the court held that grounds that could have been but were not raised in a petition were not subject to estoppel. Here, however, the court expressed some reservation about its decision that under Shaw, a petitioner cannot be stopped from asserting a public reference that was never presented to the board, finding that such a conclusion confounds the very purpose of this parallel administrative proceeding, and that the court, however, could not divine a reasoned way around the Federal Circuit's interpretation of Shaw. Again, on the other hand, the Patent Office and Great West Casualty versus Intellectual Ventures found that grounds that could have been but were not raised in the petition may be subject to estoppel. Here, the board reasoned that Congress would not have included the additional words or reasonably could have raised after raised if Congress had desired to limit the estoppel to grounds actually raised. And lastly, we see here that even some district courts are beginning to question Shaw's applicability to grounds that were never presented. As opposed to the court's holding in Intellectual Ventures that a ground that could have been but was not raised in the petition is not subject to estoppel, the court in Douglas Dynamics versus Meyer Products out the Western District of Wisconsin held the opposite, that grounds that could have been but were not raised in the petition may be subject to estoppel. And this is where they could have been found by a diligent searcher's diligent search. Here, the court sternly addressed Shaw, providing that Shaw does not adequately consider the history and purpose of the estoppel statute, and that it does not satisfactorily reconcile the narrow interpretation of during with the broader, reasonably could have been raised language. The court provided that the more reasonable interpretation is that during the inter partes review includes not only the instituted review itself, but also the petition process. In light of these inconsistencies between the PTAB and the district courts, the Federal Circuit will likely have to step in to resolve these inconsistencies with regards to the grounds not presented, and also with regards, at some point, to its holding regarding non-instituted grounds. So here we have a couple of takeaways for petitioners. First, petitioners should carefully consider estoppel scope and limitations associated with the particular form it plans to raise a subsequent invalidity argument in. And further, at the PTAB, you should be aware that as petitioner, you have the burden of proving that estoppel does not apply by showing why a reference would not have been found by a skilled searcher's diligent search. And for patent owners and the district courts, you may have the burden to prove estoppel applies rather than the petitioner or the defendant. And further, although there is no statutory IPR estoppel in the district court, you may still be subject to estoppel within the patent office, such that a patent owner may not obtain a claim that is not patentably distinct from a canceled claim. And two, prosecution history estoppel within the district court may apply based on statements made during the IPR. And with that completes my portion. I'll turn it back over to Gary.
All right, you can see the first CLE code is district. And we will now move on to our second topic with Myung Shin. And she'll be talking about concurrent proceedings before the PTAB and the district courts. Looks like we're a little bit ahead of schedule. And we'll see that we certainly should have enough time for questions at the end. If you wish to put questions in, you can put them in by typing them into the question box in the interactive screen. Go ahead, Myung.
Thank you, Gary. Hello, everyone. My name is Myung Shin. Jafong just talked about one aspect of interplay between the PTAB and district courts. Today, I'd like to talk about another aspect of the interplay between the PTAB and district courts, which is whether a PTAB's decision is binding on the district court. In general, the PTAB's decisions are not binding on the district court, but many district courts found that PTAB's decisions are persuasive, and a lot of district courts tend to give weight or deference to the PTAB's decisions. But there is a little exception to that general principle. If the PTAB's decision results in invalidity and then the case appealed to the Federal Circuit and Federal Circuit affirms the PTAB's invalidity holding, then there may be some binding effects in a co-pending district court litigation. So I'm going to discuss that. The first case that I'd like to talk about is the PTAB's decision regarding indefiniteness issue. So Tunas Enterprises versus Telebrand case, this case came out in January 2017. In that case, the Federal Circuit found that claims are not invalid for being indefinite. But about a month earlier than the Federal Circuit decision, the PTAB actually reached a completely different outcome about indefiniteness. There was a co-pending post-grant review trial, and in that trial, PTAB actually found that the claims are invalid for being indefinite. And in that decision, the PTAB applied different indefiniteness standard defined in Reed-Packard case. And the PTAB explained in detail that in Reed-Packard standard is the right standard in AIA proceedings. In the district court case, the district court and the Federal Circuit applied the indefiniteness standard different from in Reed-Packard standard. That standard is actually set forth by U.S. Supreme Court in Nautilus versus Biosig Instrument case. But the Federal Circuit did not differentiate the Packard standard and Nautilus standard. Rather, the Federal Circuit noted that there was an inconsistent PTAB decision. However, the PTAB decision is not binding on this court. So this case kind of gives the example of how the district court treats the PTAB's decision about indefiniteness issue. So how about claim construction? We all often come across the situation where the PTAB and district court come up with a different or identical claim construction of the same term of the claims. In general, PTAB's claim construction is not binding on the district court. So I'd like to briefly take a look at the two different claim construction standards applicable to the PTAB and the district courts. As we all know, the PTAB applies the broadest reasonable interpretation standard in AIA proceedings. So we call that as BRIE standard. And the district courts apply Phillips standard. And if you can see from the chart that appears on slide number 25, BRIE standard and Phillips standard have significant overlap. So claim construction under both the standards start from the language of the claims. And claims are construed under both the standards from the perspective of one skilled in the art. And claim construction should be made in light of the specification of the patent. If so, how does BRIE standard differ from Phillips standard in practice? In one case, Facebook versus Pragmatist case, the Federal Circuit stated that the BRIE broadest reasonable interpretation of a claim term may be the same as or broader than the construction of the term under the Phillips standard, but it cannot be narrower. So in some cases, the district courts tend to give a deference or weight to the PTAB's claim construction. So slide number 27 shows representative cases that the district courts decide to give deference to the PTAB's claim construction. In both cases, the district courts clearly recognize that the PTAB's claim construction are not binding on the district court, but nevertheless, the district courts find that the PTAB's claim constructions are persuasive, helpful, informative. In other cases, district courts refuse to give any deference to the PTAB's claim construction, citing the different claim construction standards. So PTAB is also not bound by the district court claim construction. Also, the same reason PTAB applies the BRIE standard. But in Power Integrations versus Lee case, the Federal Circuit actually noted that in this case, the board may have obligation to evaluate the district court's prior claim construction and determine whether it was consistent with the BRIE standard. The reason for that is it's not because the district court's prior claim construction is binding on the board. It's rather because one of the party presented the district court prior claim construction as their claim construction. So what about PTAB's decision involves validity or invalidity? Prior validity holding by the PTAB is generally not binding on the district court. The reason for that is in a second invalidity challenge, a party must be different. In a lot of cases, most likely a party relies upon a different piece of prior. So interesting case, the Inri Pratigrady case, the court was talking about the stay of the litigation and decided to maintain the stay, citing simplification of the issues, and then the district court said that if the PTAB decision of holding validity is affirmed by the Federal Circuit, then there may be some possibility that that decision will have a stare decisis effect if it's based on essentially the same record. The last decision from the PTAB, if it involves invalidity and then it's eventually affirmed by the Federal Circuit, then unlike the prior issues, this invalidity holding may have some binding effect on the pending district court litigation. The reason for that is if a claim is canceled, then the cancellation of the claim will extinguish any cause of action based on the claim. The final invalidity holding by the PTAB affirmed by the Federal Circuit will result in cancellation of claims. And the similar situation arose in Presenius versus Baxter case. This case is actually a pre-AIA case, so the Presenius defendants filed ex parte re-examination, and then at the time the infringement litigation was ongoing with the district court. And then the case went up to the Federal Circuit from the infringement side and validity side, and the Federal Circuit affirmed the invalidity holding by the PTAB, which was presented based on the different piece of prior. So Pat Owner Baxter argued that there was a final judgment entered by the district court, and cancellation of the claims by the patent office cannot reopen the final damages judgment at this stage. But Federal Circuit basically disagreed with the Baxter. The reason for that is the status of the district court litigation was actually not final. Liability determination was made, but the parties were still disputing over the form and the amount of relief based on liability. So the Federal Circuit saw the status of the litigation as not being final. So cancellation of claims pretty much extinguishes any cause of action based on the patent, and Federal Circuit actually remanded the case to the district court to with the instructions to dismiss the litigation. So my takeaways from the discussion today is that the Federal Circuit district courts usually find that the PTAB's decision involving indefiniteness claim construction are not binding. The little exception is that the PTAB's decision affirmed by the Federal Circuit results in cancellation of claims. Then cancellation of claims may have some binding effect in non-final co-pending district court litigation. And one thing that I also like to suggest is that practitioners, when they have a favorable decision from the PTAB, they should consider how to use PTAB's decisions before the district court. So in one case, there was a jury's willful infringement finding, and PTAB actually rendered the final invalidity decision, and then defendants actually presented the PTAB's decision to the district court and indicated that PTAB's decision shows that defendants' belief that the patent was invalid was reasonable. So based on that evidence, district court actually vacated the jury's willful infringement finding. So this is kind of one example of like being creative and proactive about how to use the PTAB's decision before the district court. So I'd like to suggest that petitioners should consider the use of the PTAB's decision before the concurrent district court litigation. That's the end of my presentation.
Thank you, Myung. We have our CLE code number 2 for those of you who are interested in getting CLE credit, and that word is estoppel. Now Alex will be presenting on our last topic, which is the stay motion success rate, and any questions about discrepancies between the districts. I think you'll see some of those in his presentation. So Alex, it's all yours. Take it away.
Thank you, Gary. Welcome again, everyone. My name is Alex Wang, and I'd like to direct your attention to the third topic today, tracking the stay motion success rate. So as many of you may have known from your practice, when you do have parallel proceedings in both PTAB and the district court, besides the issue of estoppel my colleague Jeffan just talked about, another strategic decision you have to make is whether to stay the case in the court pending the IPR, PGR, or CBM review. So when you do decide to file a motion to stay, what are the factors considered by the courts? For the IPR and the PGR, the courts usually apply the traditional three-factor test, and for the CBM review, the tests are statutorily codified. In particular, the courts, when considering a motion to stay pending IPR, they evaluate the first stage of litigation. This factor should generally be evaluated at the time when the motion was filed. Second, whether a stay will simplify the issue in the case. And third, whether a stay will create undue prejudice to the non-moving party or a clear advantage to the moving party. Notably, Federal Circuit has held that the district courts are not limited to only consider these three factors. In one 2016 Federal Circuit decision, Murata versus Daifuku, Federal Circuit held that a district court may also consider the burden of litigation on the court and the parties as an additional factor. As you will see shortly, this makes the IPR the motion to stay pending IPR very similar to the factors considered by the courts when evaluating a motion to stay pending a CBM review. So here we have the four factors codified in the statute about what to consider when evaluating a motion to stay pending a CBM. The first factor, whether a stay or denial will simplify the issue, is basically the same as in the previous slide. The second, whether discovery is complete or whether a trial date has been set. This factor generally corresponds to the factor of stage of litigation in the previous slide. And the third one, whether a stay or denial would unduly prejudice the non-moving party or present a clear tactical advantage to the moving party. And the fourth one, which is not usually considered by the district courts when evaluating a motion to stay pending IPRs, here is whether a stay or denial will reduce the burden of litigation on the parties and on the court. So now, let's look at some statistics about the motion to stay success rates after the EIA came into effect. So this slide depicts the overall success rate from 2012 when the IPR, PGR, CBM review first came into place to the end of 2016. As you can see, there's a significant increase in the number of motions to stay filed in the courts from 2013 to 2014. However, the overall success rates from 2013 to 2016 stay basically the same, around 60%. As for 2016 in particular, the overall success rate is 63%, and about 27% of the motions were denied. One thing to note about these statistics is that these numbers covers both stipulated motion to stay and contested motion to stay. Next, we turn to the success rate of contested motion to stay. As you can see, the success rate dropped significantly from about the overall 60% to around 43% from 2014 to 2016. And you can also see there's a projection for the year of 2017 based on the number of a motion to stay filed so far in 2017. And the projection is that the success rate may further drop to around 35%. Here, based on the number of motions to stay received during the period of 2012 to 2016, we have the top 7 districts. And as you can see, there is a wide range of success rates among the different districts. The Eastern District of Texas generally grants about 30% of the motion to stay, which I think this data covers both stipulated and contested stay motions, whereas Northern District of Illinois or the District of Massachusetts, they grant about 60% of the stay motions in front of the court. This slide, now we have a more recent time frame from 2014 to 2016. Here you can see there's a wide range of success rate among the different districts. The Southern District of New York grants about 70% of the motion to stay, whereas the District of Connecticut only grants about 37% of the motion. So how about in front of individual judges? And again, there is a big discrepancy among the success rate in front of individual judges. Take the District of Delaware as an example. Judge Sleet grants about 80% of the motion to stay in front of him, whereas Judge Andrews only grants about 11% of the motion to stay in front of him. So one important factor that impacts a judge or district court's decision to grant the motion to stay is whether the IPR, PGR, or CBM review has been instituted. As you can see on this slide, before, and this is based on data from June 2014 to June 2015, before the institution decision, only about half or less than half of the petitions were granted, the motion to stay were granted. Whereas after the PTAB has decided to institute review on the petitions, the motion to stay success rate raised to about 64%. More specifically, we have Northern District of California and the Eastern District of Texas. Whether the PTAB has instituted trial heavily affects the outcome in some districts, well, not at all in other districts. For example, in Northern District of California, up to fall 2015, the motion to whether PTAB has instituted the review only slightly impact the success rate of the motion to stay from 71% to 81%, whereas in the Eastern District of Texas, after the PTAB has decided to institute review, the success rate raised dramatically from 8% to 67%. So a few takeaways from all these data. First, Because of such variance and discrepancies among different districts or even individual judges, we recommend whenever filing a motion to stay, you carefully consider district courts and the judge's general practice. Second, as mentioned before, one important factor when evaluating the motion to stay is the simplification of issue in the case. So in your motion to stay or in the brief supporting the motion, you should emphasize this point. However, the scope of estoppel may impact this factor and may impact how a judge may evaluate how this factor, how the simplification of issue factor is weighed. Third, we recommend file early. Even if the motion was denied before institution, most of the time the denial will be without prejudice. And later on you can renew the motion. And given the Federal Circuit's case law that generally the stage of litigation factor should be evaluated at the time when the motion was filed, this help filing early give you a benefit of putting a stake in the ground and setting the time where generally the stage of litigation factor should be evaluated. Also, when you file early in the case, usually little discovery has happened, and it will benefit supporting your brief. Regarding prejudice, file early in the case will be less likely for a petitioner to be blamed for the delay early on. And that concludes my part of the presentation. Thank you.
Great, thank you, Alex. Here is our final CLE code or factor. Now we have some time for questions, and we certainly have enough time for questions that we could present from the audience. I'm looking to see if there was anything written by anybody as questions. I don't see anything right now, but we can certainly wait for you to type in something if you wish in the Q&A box for questions you may have of either Alex, Jafan, or Myung. I've got a couple questions in the meantime. Jafan, you were talking about Shaw, you were talking about the various interpretations of Shaw by the district courts and how unsettled things appear to be. I've heard some people talking about maybe trying to include more grounds in a petition with the thought that if you get certain grounds allowed and certain grounds not instituted, or say certain grounds instituted and certain not, then you have a clear statement from the PTAB that certain of those grounds were not instituted and therefore not estopped. So based on that kind of approach and what you've seen in the cases, do you think a petitioner should include more grounds in its petition at the PTAB or fewer grounds? And what about the page limit for doing these IPRs?
So it depends, Gary. One, if petitioner expects that there will be subsequent litigation in the district court, and they want to consider presenting more rather than less grounds of invalidity in its petitions, there's no estoppel in the district courts will apply to petitioned but non-instituted grounds. However, in a recent decision from the same judge out of the Western District of Wisconsin, Douglas Dynamics versus Meyer Products, the court did caution that grounds presented on bad faith that are denied may be subject to estoppel. However, on the flip side, this tactic will not likely be as attractive if a petitioner suspects it may raise a second challenge to the same claims in a subsequent proceeding at the Patent Office, because the Patent Office reads the estoppel statute much more broadly than the district courts.
Okay, thanks, Jafan. Now you were talking about final written decisions by the PTAB. What about preliminary decisions, the decision to institute or decision not to institute a trial? How do the district courts consider those?
That's a really great question, Gary. PTAB's preliminary decisions, I meant to say a decision to institute or denial to institute a trial. So it really varies. So some district courts say yes to those, and then other district courts say no. But it's consistent that a lot of district courts have expressed concern about letting the party relying on those preliminary decisions in light of the preliminary nature of those decisions, because once those decisions are presented to the jury, then jury may be really confused about evidentiary value of those decisions. So a decision to institute means that the patent is invalid, or a denial to institute a decision, the trial means that the patent is valid. So there are a lot of nitty-gritty details attached to those decisions, and it may be ultimate outcome would be different at the end of the trial. So most of the district court concerned about such confusion by the jury, and then potential prejudice to the party, like for the institution decisions, a patent owner denial to institute a decision for a petitioner. So for some district court, they decide to let the party rely on those decisions, but they put some proper measures and then limit the scope of the reliance by the parties about those decisions to make sure that, only a relevant portion of the decisions can be introduced as evidence and relied upon by the party, and then, try to limit the confusion by the jury and potential prejudice to the party.
Thanks, Myung. Any questions on the telephone? If anybody would like to speak any questions that they may have to any of the panelists. I have a couple more that I'd like to ask, but I want to make sure there's time for the audience to ask questions.
Carrie, can I add one more point in connection with your question?
Sure.
So, Alex, do you mind going back to the slide number 27? So during my discussion today, I talk about a few representative cases by the district court that the district court decided not to give any deference to the PTAB's claim construction. So if you go to the next slide. Yeah. Next. Yeah, so the second case, the district court decided not to give any deference to the PTAB's decision, and the decision that we're talking about here was actually a preliminary decision, so it's a PTAB's decision not to institute a trial. And in reaching that conclusion, the PTAB actually included claim construction in the denial decision. So I just want to mention that the district court's refusal to give any deference to the PTAB's claim construction in this case may have some tie with the preliminary nature of the PTAB's decision. So the district court position might have been different if the claim construction by the PTAB may have come out from the final written decision. So I just want to point that out.
Yep, thanks for that clarification. Anything from the audience at this point? All right, let me mention a question to Alex. So Alex, we're talking about the different scopes of estoppel that are interpreted by the district court and the PTAB. And in particular, when you're thinking of the district court, do you think that the scope of estoppel that's considered by the district court is going to affect a likelihood of success on the state motion?
That's a very interesting question, Gary. Actually, I think it very well does. And the reason is that the courts are already beginning to see many of the cases where the court granted a stay and then IPR was instituted and then there was a final written decision. And then the party came back to the court after the lifting of the stay. The parties start to fight about what are estopped, what are not estopped. So the uncertainty at the current stage of the scope of IPR estoppel actually gave more headaches to the courts, even though the case was previously stayed and then now the stay was lifted. So some of the courts actually have said that maybe from now on we should give more thought to this, and maybe the courts will be more cautioned about giving stay pending IPRs, PGRs, or CBMs. And for example, in one of the 2016 district opinion from District of New Jersey, the Diplomat versus Purdue Pharma case, the district court said the post-IPR viability of Purdue's 102 and 103 defenses in light of the Federal Circuit's decision in Shaw may impact the court's decision going forward regarding whether matters should be stayed pending IPR. So that gave you a clear signal that the district court may be more cautious about granting stay going forward.
Jafan, what about a patent owner and the estoppel issue? If a patent owner wants to limit the number of invalidity grounds a petitioner can subsequently raise in the district court after a petitioner's IPR challenge has been rejected in the final written decision. What should a patent owner do then?
So here, Gary, a patent owner should definitely focus on showing how any newly raised documentary reference could have been found before by a skilled searcher's diligent search. Patent owners should also consider presenting expert testimony on why a particular search which found the reference would have been conducted by that skilled searcher.
And the burden is on the patent owner in the district court?
Yes. As the proponent of the estoppel argument, the burden will be on the patent owner at the district court.
All right, I think we're nearing to a close here in our presentation. I want to make sure again that we have time for any questions from the audience. I didn't see anything in writing. Does anybody have something orally they want to raise with us? Okay, I don't hear any, but I want to make sure that you're aware we're going to have another webinar coming up, which will be presented by our litigation practice group June 14th at noon. Some of the topics we plan to discuss, and we're still finalizing the presentation, would be role of opinions in counsel, post-HALO, patent venue in view of TC Heartland, perhaps an analysis of the Middle District of Florida and other jurisdictions for patent venue, and some current developments at the PTAB itself, and procedures and otherwise. And if you would like to attend, please email Joe Flynn, jflynn@brinkskilson.com. And Joe will be sending out an email to those of you who have signed up and participated, letting you know how you can obtain copies of the presentation and any CLE requirements that you may need to meet as a result of your participating in this presentation. I think that's it. I don't see any questions coming from the audience. I want to thank you very much for participating. I see that some of the participants are people that we know and have dealt with before. We appreciate your attending. And if any of you have any further questions that you'd like to raise later, feel free to direct them to Joe or to me or to any of the participants here at